Good afternoon. My name is James Vann, and I'm one of the attorneys here at Vann Attorneys, and we are so thankful that you are participating with us today. We really hope this will be a helpful webinar for you. We're going to be talking about bankruptcy, when your customer files bankruptcy and what that means for you. I just want to say a quick thank you to Michael Fernald. Michael is part of our team and does an amazing job of helping us put all this stuff together. So thank you so much, Michael. He's been a dear member of our team for many years and a great friend. So thank you, Michael. So if you've got questions today, you can use the control panel on the GoToWebinar control panel and send them that way. Or you can send it by email at webinar@vanattorneys.com. So we're going to be talking about bankruptcy, especially from your customer's perspective, right? What happens when they do file bankruptcy? How do we respond? What do we do? The automatic stay. What is it, and how does it work? How do you prepare for your claims, and then dealing with preference claims? So I know a lot of y'all join us every time or many times that we have webinars, and we are so thankful that hopefully that's helpful to you. If you have any questions today, make sure you send them. But if you have it later, because we're going to cover a lot of information, there are a lot of slides, so we're going to be moving hopefully pretty quickly. And I hope that's not. I think y'all will get it, but there are a lot of slides compared to normal for our normal stay. So the effect of the automatic stay, and what is the automatic stay? We'll talk about that. So what happens when someone files bankruptcy? The bankruptcy court wants to say, okay, everybody stop where you are, creditors stop, the debtors are supposed to stop some things as well. We want to make sure that we preserve the status quo. That is, the debtor doesn't get sued anymore, or no one starts taking assets away from the debtor. We just want to stop everything, see what's there, right? What assets are there, what debt is there, and then determine how to distribute those. So the automatic stay is, automatically when they file bankruptcy, everything stops, right? You're not, as a creditor, we're not supposed to send demand letters. We're not supposed to send invoices, not supposed to file suit, that kind of thing, without permission from the bankruptcy court. And the automatic stay is based off the bankruptcy code. And within a few exceptions, when that happens, when they file bankruptcy, the automatic stay kicks in and it stops creditors and any other entities from stepping in and trying to take possession of the bankruptcy estate. Think about it this way, right? You want to get paid as quick as you can from your customer if they're filing bankruptcy. But you also don't want another creditor stepping in and grabbing everything and running, right? So it's sort of fair, I guess, to everybody. Sometimes it sort of messes people up, right? From a standpoint of trying to collect money, but that's just what happens, right? So the automatic stay does not apply to co-defendants or co-defendants in an action. For example, if you've got a corporation that files bankruptcy and you have a personal guarantee, but the individual personal guarantor does not file bankruptcy, just the business, you still could go after the personal guarantor for the money that is owed to you. Or, for example, let's just say there's 2 or 3 companies that you're dealing with that might owe the money. If there's a joint check agreement, maybe, or something of that nature. And I say that with a little bit of a caveat, depending on who files bankruptcy, if there's a joint check. But let me leave that part of it out just for a little bit. But let's just say there are 3 companies that owe money for this indebtedness. If one of the companies files bankruptcy, you still can go after the other 2. So again, there's some co-defendants typically not included in the automatic stay. There are a few exceptions where the bankruptcy court says, chasing the guarantor, who is also the owner of the business that has filed bankruptcy, is that they're so closely tied together that impacts the bankruptcy. Sometimes I've had bankruptcy courts tell us that we can't go after the personal guarantor. That's generally, an argument with the court, but that's generally speaking, that doesn't happen. So hopefully that makes sense. The automatic stay is uniformly applicable to all bankruptcy cases. It applies to all creditors and third-party actions that might affect the case, that is the bankruptcy case, and the property of the debtor. So hopefully that makes sense. All forms of secured creditor action are stayed. For example, if you've got a deed of trust, if you've got, UCCs, those kinds of things typically are stayed as well. Now, though the secured creditor can come in and say, I want relief from the stay so I can go after my asset, right? But initially they're stayed. Informal actions such as repossession, the power of foreclosure, all that stuff is stayed, at least in initial stages. It also stops all case actions, right? Let's say, for example, that we've sued a company on your behalf. We're in state or federal court, and then the company that we're suing files bankruptcy. It stops that action, at least temporarily, until we sort of decide whether or not we can continue. But we have to get the bankruptcy court's permission to continue. Sometimes the case may then come over to bankruptcy and you try it there. Just depends on the circumstances. It also includes arbitrations, administrative or other informal proceedings, even mediation in a case. It would stop that or stay it. So if a creditor is considering some action against the debtor, right, they want to take some action to try to collect the money, the property of or possession of the debtor, it's best to seek the advice of your attorney. Look at the code, look at case law. Can you do that? For example, a number of years ago, we had a bankruptcy judge who said, and this was in the height, I guess in the 90s, and then in the early 2000 phrases as well, or time period as well. We had a bankruptcy court judge who said you cannot file a lien if the debtor is in bankruptcy. And that was when, in some of the downturn of the economy, we were struggling because you had to file an action. Sometimes you couldn't get in front of the bankruptcy court in time to file the lien. And so a lot of times we filed the lien and then filed the documents to the bankruptcy court to ask for permission or for forgiveness. One of the judges was not very happy with it, and a lot of us were doing that, right? It just wasn't us. It was a lot of lawyers across the state that were doing that. Again, you can do certain things like file a lien. Even now, thankfully, the judge sort of backed up on that position, and most courts would support that. You can file a lien even if someone's in bankruptcy, but you cannot file the lawsuit to enforce it without either getting bankruptcy permission or just saying, I'm giving this for notice purposes only. So it's really much better to seek the relief that you're trying to get, talk to your lawyer, try to make sure everybody knows what's going on. And again, if you get notice of your customer filing bankruptcy, you really should not send demand letters. Don't start calling them. Don't try to do a secret, deal around the corner to get paid so that you don't have to go through the bankruptcy. For violations of the stay, the automatic stay, it's considered any actions that's taken by, for example, the creditor and debtor work some kind of a deal. That's void, and that is meaning that it has no effect, and the bankruptcy court can truly undo all of that, and it really could create some serious consequences for the creditor. We've had a few clients over our years that will ignore the automatic stay and either try to collect the money or have a sweetheart deal with the debtor on the side. It comes to light, and all of a sudden the creditor is in trouble with the bankruptcy court. It could include sanctions, which is monetary penalties, giving the money back. It's pretty serious. And I'll tell you, I have been in the court, not thankfully with our clients as much, when the court or the judges are looking at the creditor, and it's not fun. And they have a lot of power, so you don't want to do that. Some courts have held that the actions taken in violation of automatic stay are voidable versus void. Again, that's sort of a legal, difference. That is, they can undo it all and say put everything back where it was. They can get contempt findings, but again, certainly attorney's fees, costs, and damages. You don't want to be in that game, right? That's just not something else you want to deal with. If the violation is considered to be willful, the debtor may recover actual damages and punitive damages. That doesn't happen. I don't see that as often, but I do see a lot of times where the bankruptcy court will go after a creditor for actions of the violation of the automatic stay, try to get attorney's fees and so forth, and penalties for it. So that's not a place where you want to be. So claim preparation, what do you do, right? How do you best protect yourself and your company if one of your customers files bankruptcy? Well, start gathering the documents. I know many of y'all keep that well organized anyway, but gather your documents, make sure you got everything that's you need for the invoices. Look at your delivery tickets, look for the accuracy, make sure you got your credit application, see who signed your credit application. Do you have personal guarantees? And then you want to prepare to submit a claim if you can make a claim if there's any assets in the bankruptcy estate. So a trustee can avoid a claim if there's a transfer. This is for the preference right, the claim preparation. Trustee may avoid a transfer if the payment to a creditor was from the debtor, right? That's property of the debtor to or for the benefit of a creditor on account of a past due or antecedent debt made while the debtor was insolvent. And there is a presumption that there's 90 days before they file bankruptcy that they're insolvent. And then the creditor receives more than it would have in a liquidation. That's what they have to prove to say it's a preference. So again, any transfer of property belonging to the debtor, payable to a creditor for account that's past due while the debtor within that 90 days, and then they get more than they should have gotten in a liquidation. That's sort of the definition of it, right? Knowledge by the creditor that the debtor is insolvent, not required. You don't have to know that they're broke that 90 days or 80 days in. You probably, if you're talking to them, you probably know it anyway, right? But you don't, it's not a requirement. Generally, the creditor has no knowledge of the debtor's insolvency. And then the trustee's got to prove every element of that transfer. So we'll talk about some ways to hopefully, if you realize that you've got a customer that may be looking at bankruptcy, how do you maybe set up a payment so that that doesn't happen? So we're going to look at each of the elements. So transfer is any kind of mode, like direct payment, indirect, voluntary or involuntary transfer of an interest in property. The definition is really broad, and they did that for a reason, right? So that they can capture as much of a transfer of property as possible. So it's a transfer of property that belongs to the debtor, right? That's not necessarily defined in the bankruptcy code, but the courts have said it's a property which will become property of the bankruptcy estate. So if you, for example, let's say that the company is, ABC company, and that's who your customer is, and they file bankruptcy. If you've got a guarantee, or if there's another company that's related or very closely connected to ABC, and for example, that you have a relationship with them, or you're working out a payment schedule, you could say, hey, look, instead of ABC paying me, because you have a feeling that they may be getting ready to file bankruptcy, I want the owner to pay me individually. Because say the owner's cash flush, right? That's not property of the debtor, right? Probably not going to show up as a transfer of an asset from the debtor. But then you got to make sure that the individual doesn't file bankruptcy. So you got to make sure that if they're really strong financially, you can set that up so the individual pays you versus the company. Or if that individual owns another company, you say, you know what, I'd really have the payment coming from company XYZ versus ABC. Again, that's a possibility of setting those things up. So the payment is, again, a payment to a creditor of an asset or something that belongs to the debtor for the benefit of a creditor. Creditor's got to be involved in it, obviously, for a antecedent or past due account made while the debtor is insolvent. And again, statute says or presumes to be 90 days prior to them filing bankruptcy that they are presumed to be insolvent. Made within that 90 days prior to filing bankruptcy. And again, so what the question is, when does the transfer happen, right? Let's say, we all deal in checks still. Let's say a customer gives you a check today and you deposit it today, right? So you count out 90 days. Is it from today or is it from tomorrow, right? Or when the check clears? And there's case law that sort of falls all over that. But let's say they gave you a check today that was dated April 1st, right? Instead of today. It's dated April 1st. They hadn't given it to you. They've been carrying it around and they finally gave it to you today. You deposit it tomorrow. So what's the 90 days? Obviously we'd love to argue the 90 days happened April 1st, right? When they wrote the check, was when they dated the check. more than likely the bankruptcy court's going to say, what day did it clear, right? When you held it for, or either you held it or the customer held it and didn't give it to you, they're going to probably look at what the date that the money was transferred from the debtor's account to yours. If you looked at ACH transfers or wire transfers, it's going to be the date that it transfers out of their account, and you count 90 days from that. So there's a few things that you can manipulate, not manipulate, a few things you can argue on that 90 days, but that's typically what happens. So, and again, and then the number 7 one enables a creditor to receive more than they would in liquidation. The idea is if they liquidated everything and just paid everybody out pro rata, how much would you have got? That's how they determine that piece of it. So let's look at the defenses and exceptions to the preference rules. So how do you avoid the preference claims, right? So a preference must be proven before you get to the exceptions, right? They've got to prove that it was a preference claim, right? Or preference payment. There's got to be a transfer, antecedent debt. We talked about all those things, right? How can I defend that preference claim? This defense of a contemporaneous exchange, let's say, for example, that you've got a customer that owes you $50,000 and they want to, come in and order or purchase whatever, another 25,000, right? You go, nah, I'm cutting you off at 50. I'm not giving you anything else. And they say, I'll tell you what, I'll pay you 25, but I also need to get 25, right? So the $25,000 payment that you get, and you allow them to have $25,000 more of materials or a loan or whatever it is that you're providing, that's a contemporaneous exchange. So that if they file if they got the materials today, paid you the 25,000, and then you gave them another 25, that's a contemporaneous exchange, right? For new value and for that materials, right? Contemporaneous exchange can also be like COD, right? So that's not going to be a preference claim. You gave them something, they gave you something. So we've talked about what that is there. A contemporaneous exchange. Another one is it was an ordinary course of business, right? So you look at the payment from your customer typically, right? Your terms may be net 30, right? So if your terms are net 30, but let's just say the customer typically pays you 45 days, like almost clockwork, right? So use the defense of an ordinary course of business. The transfer must be in a payment of a debt incurred in the ordinary course of business, made in the ordinary course of business, and made according to the ordinary business terms. So you might say, hey, look, my terms are 30, but they always pay within 40 or 45. They've done that for 2 years, right? What you would do is you look back at your payment schedule, right, or your pay history with your customer and say, yep, here was the average number of the days they paid on their invoices. That gives you the ordinary course of business. And if that pushes out to say, 60 or 90 or 80, well, that's a defense, right? So you could use that as a possible defense. The intent of the defense is to allow for the ordinary normal credit transactions, which are handled on a current basis. So the other question you look at was, when was the debt incurred? This defense is lessened by creditors who have altered their credit terms because they believe the customer is financially weak. Normally you have 30 days, right? All right, I'm going to give you 45 days, or I'm going to give you 60, whatever it may be. And you change that, right? With that one exception for this one customer. That could bite you in the end because you changed it to say that my terms were 30. Now I've changed them to 60 because I think you're financially struggling. And that may not be within the ordinary course if it's pushed out much further. But again, that's something that you can look at. But again, you look at what's ordinary course of the business and your relationship with that customer. And you also can look at what's ordinary in the industry, right? So in the industry, typically, this type of customer pays in 45 or 60 days, whatever that term is. I know we have not had many cases go to trial. What happens when you have a preference claim is you'll get a letter from the trustee's office to say, by the way, the $45,000 that you got 6 months ago or 9 months ago, you got to return that. Don't do it. Hire an attorney that knows this stuff and deals with it, and let them negotiate it for you. You may wind up getting sued by the trustee. Don't panic. I can't guarantee you this, but I can tell you my experience and most of the experience of the lawyers that have been in our office, you can negotiate those preference payments down. So just because they file suit, right, you don't want to panic and just start throwing money at them. Even though you don't, look, I get you don't want to pay your attorney and pay the claim, but a lot of times you can negotiate those things down to save some money. So look at what's ordinary in the course of your transaction with your customer, but also what's ordinary course in the industry, right? It could be, there'd probably be different terms. So sometimes you have to hire an expert or someone that's very knowledgeable in the industry to say, well, in this industry, the normal payment terms are 45 or 60, right? Whatever that may be. And again, we talked about what's ordinary course between the parties. Where there's an account that's been open long enough to establish a history, right? You want to go back and look at it. What are the specific terms that are stated? And then the key is for the alleged payments must comport to the normal practices. So again, what you're trying to say is the payment that I got that the debtor, that the trustee thinks is a preference claim, you say, no, that was typically, they always paid me within 45 or 60 days, right? They never paid me 30 days. Again, it gives you some defense. We talked about new value. The defense is after where the debtor and the creditor have more than one transaction, and the transactions are to be netted out. And I talked about the contemporaneous exchange. So contemporaneous exchange and new value sometimes look very similar. So contemporaneous exchange could be a COD, or new value really is where you say, I'm going to give you $50,000 worth of material, but you're going to pay me $50,000. I'm going to apply it to your account. Again, it's sort of the same transaction, but it's another defense for new value. So you're giving money, or money is worth in goods, services, or new credit. And any new value given should be unsecured and may also be applied against subsequent later transfers. There's another defense about when you give up a statutory lien, right? If the creditor in construction setting has lien rights against property or money, and they've perfected the lien by filing it, generally the creditor's lien rights will prevail. So for example, I had lien rights, right? And typically you have to file them for this to work. So you file your lien, say for $100,000, you get paid $100,000, you release your lien, right? And they come back later and say, oh, by the way, that $100,000 that you got is a preference payment. We want it back. You go, no. I'm not giving it back because I gave up something. I gave up my lien rights. Where that argument doesn't work as well is that I had lien rights, but you didn't file them, right? You didn't file the lien. That's a little bit harder of an argument to make with the trustee. We have made it before, right? We had lien rights. Let's just say, for example, and I think this truly could work, and I think it should work by statute. You didn't file your lien, right? But you had lien rights, but they paid you because you're getting ready to file the liens, right? I'm getting ready to file liens on your project. They go, no, here's your $100,000, and you sign a waiver, right? You've waived your lien rights at that point. I think that argument works. Where there's no discussion at all, I think it's really a tough argument. There are a few cases that I think open that door a little bit, but it's a little bit harder. So I hope that makes sense. Again, we talked about what's ordinary course within the industry. Again, the claim preference payments made 48, 50, and 62 days within the payment terms, right? And an industry norm for payment on accounts may be 45 to 60, right? If that's where it falls, there's a good argument that that's not a preference payment because it was in the ordinary course of the industry. But again, you got to know what that is in the industry and be able to prove it. Again, I don't think I've ever had a preference claim actually go to trial in a bankruptcy court. A lot of times they settle out, and neither side wants to do it, right? Certainly the creditor doesn't, and the trustee's office doesn't typically want to do it. A new value we've talked about. It's new credit purchases. which would not be permitted, but for a payment, right? They gave you a payment, you gave new value, and they, gave something new, right? So what do you do if you receive a demand for an alleged preference payment, right? Do you do nothing? That's not a good idea, right? Do you respond to the letter? I think you should. Do you send a check back? No way. Don't send the check back. Please don't pay that preference claim. Talk to your attorney. Look at your defenses, right? A lot of times when we send a response back to the trustee's office, we say, hey, look, a lot of times we get it. We talk to our client. We get the information and go, hey, look, we're responding to your demand for the money back as a preference, but it's not a preference, and here's why, right? We outline the defenses. And sometimes, sometimes you can support that when you send the letter back. And sometimes there's conversations back and forth, depending upon how much time the trustee has before they have to file the lawsuit, or whether or not they just want to get it done and get all the assets into the estate to distribute those. But it's one of those timing things. You want to negotiate those things down, and don't panic when you get that letter, even though getting that letter is never fun. When you receive the letter for demand, right, for an alleged preference, consult with your attorney, right? Look at what the details are. Look at your payment history. Look at what you've given up or what you may have given in new value, what defenses might work for you. Is it possible that the funds could be wired to make the payment, right? Planning for potential preference. So if there's a chance that you could get the debtor's attorney, the money to come from maybe the debtor's attorney's trust account, it's still the debtor's money. But I think if you could get the money to come from the trust account from his client, it puts a few hurdles in there, right? Just an idea. Or is it possible to have the debtor's bank make the payment from a loan to the debtor? That is, the debtor's going to pay you $250,000, but if they're having to get a loan, instead of the loan going from the bank to your customer and then to you, maybe the debtor gets the loan is paid to you from the bank, and then you could make an argument that it wasn't the debtor's money. Well, the debtor's got to pay it back, but it wasn't the debtor's money. Or maybe by credit card. So it's really interesting how the trustee typically looks at the bank records of the debtor and tries to see what has been debited on their account. Sometimes they look at credit cards, sometimes they don't. They are certainly not going to be looking at payments coming from like an owner of the business, or if there's another closely related business that's not going to file bankruptcy, the trustee's not going to look at that. So I don't know if that helps you or not. I hope that maybe it makes your wheels turn a little bit. So what evidence of payment by the debtor or records do the trustees review? We talked about that, right? They'll look at stuff that, and it used to be, they said, look, just show me a check register, right? And now they were looking at the bank accounts because it's all electronic, a little bit easier. A little bit harder to hide those things sometimes. How can payments be made which do not pique the interest of the trustee? So you want to think about, right, if you're chasing your business customer, right, for the payment that they owe, and you're thinking, okay, who might file bankruptcy if you're thinking financially they're weak, right? Who could make the payment to you that would not file bankruptcy? And sometimes that's a subjective call. You have no idea really, but hopefully that makes your brains turn just a little bit to go, okay, who can I say I want the payment to come from? And I hope that makes sense. So how long of a payment or long of a period of time does the trustee have to make the preference claim? It's a formula, and I started to put the formula in there, but to be honest with y'all, we have to look at it every time. It's a pretty hard formula to memorize. Typically, it's 3 years after the bankruptcy petition has been filed, unless the case is dismissed or closed. So typically, the trustee has 3 years after the bankruptcy petition is filed to bring a preference claim. So sometimes it's been year and a half, 2 years, and all of a sudden our client gets a call, or not a call, but a letter from the trustee that says, by the way, these payments you got are preference claims. You're like, oh man, didn't see that one coming. So just think through those. If you know you've got a customer that's filed bankruptcy, you might want to look back at your payment history and just say, okay, I got to earmark these. Those may be preferences, just to have that knowledge. I hope this is helpful. We have gone through a fair amount of material in a quick period of time, but I hope that's helpful to you. I know some of y'all have sent questions in anticipation of today already. I hope we hit those questions for you. And if you have other questions, please let us know. We really enjoy doing these for you. We want to make sure these are helpful. And I don't think we've gotten any questions, so that's good. I just want to double check. Thank you so much for allowing us to be part of your team. We hope you all have a great day, and thank you again.